Hi, and welcome to Let's Talk Autism with Shannon and Nancy. I'm Nancy Allspaw-Jackson.
And I'm Shannon Penrod. Welcome.
Yeah, and how was Mother's Day?
Mother's Day was really good. Jem thinks that Mother's Day means going to an amusement park with mommy, which works for me because I get to sit. I don't ride any of the rides.
Right.
I get car sick on a stationary bicycle.
Okay.
So I sit on a bench and read my book. So it's kind of downtime for me.
Yeah.
And then he gets off a ride and is very happy. And we spend time together in the park and see shows. So what about you? What'd you do?
Very low key. Just spent time at home with family and went out to brunch and all of that. So, and got lots of cards and flowers and things like that. So it was nice. And I also celebrated a birthday on Saturday.
Yes, you did.
Yeah,
Happy
so I had a little double whammy there. So it was good.
So you're 28.
Yeah, I'm 28 forever. No, 57 and proud of it.
My goodness.
Yeah.
You know what? You shouldn't tell people. No one would ever
You
know.
Why? Who cares? I own it. It's good.
You do own it. Well,
it's good.
No one would ever know either. You can say things like that when you look younger than you are. You can be proud of that.
And Wyatt made me a great gluten-free, dairy-free cake. And
wow.
Yeah. So it's
He'll have to give me his recipe.
Okay, and it was really good. You know that some of the new stuff is as good as anything. I think.
Yeah, some of it.
So, yeah.
Some of it, not so much.
Some of it like cardboard.
Yes, or worse, I'm told. Yeah. From time to time, I get gluten-free things for friends, and they say, really.
Yeah, you don't need to. Okay. So I'm excited about today's show because we've got some great information. Yes. We've got Valerie Vanaman, who is a special needs attorney who really knowledgeable, and it's a chance for those of you who maybe can't afford an advocate or attorney or don't have access to it to hear what she has to say and about things you need to be aware of for your child's education.
Absolutely.
And if you do have questions, we encourage you to email us and let us know. Yep. So that's going to be coming up in just a minute. We're going to talk about a few things. There was a study that we're going to discuss, but we're not really sure. It's kind of scientific.
I always like to remind everybody I am not an expert.
Right.
But there's things in the news that we like to look at from time to time. Yeah. And there's a new study that came out about defective carnitine metabolism and that it may play a role in autism. And I encourage everybody to go and look at these studies for themselves. But this was doctors and researchers from Baylor College of Medicine and Texas Children's Hospital that recently were studying whether defective carnitine metabolism could play a role in autism, specifically in milder forms, which I thought was interesting.
Okay.
And it's basically, to break it down into simple terms, carnitine is apparently an amino acid that has to do with the body's use of fat for the use of energy. Okay. And that there's something to do with the genes, that sometimes there's a gene deletion, that in some people a gene is deleted that has an effect on this carnitine. And so they were taking a specific look about that, and in particular, there's something called the TMLHE gene alteration. Okay. It gets really technical from there, but they were looking specifically, and they've got 3 more studies that they're going to be doing. But there was one thing in particular that I noted from this, that they said, the doctor in question, who was the head of this, said, and this is a quote, "We believe that the most attractive hypothesis at this time is that increased risk of autism is modified by dietary intake of carnitine from birth through the first few years of life." So,
well, I wonder what carnitine is found in. I do know that there is carnitine supplements, acetyl L-carnitine. So I know that my son was on that for a while. I'm wondering, and I know the study didn't say, whether we could give supplements.
Well, and
it says right there, in a 3rd study, they plan to begin giving boys under age 5 with autism carnitine or related supplement and see if it improves behaviors.
Yeah, so there's 3 studies about to come up, and at this point they are saying, nothing conclusive. And they very specifically say we cannot point to this and say that this is a cause of autism, but that it seems like there might be a prophylactic use of carnitine that could be beneficial in the first 5 years of life. So, but they're going to do the studies. We'll kind of monitor it as it comes along. It's all these little puzzle pieces that we're fitting together and saying, oh, this could help, this could make it worse. We're looking at risk factors.
What's interesting to me out of all the studies that came out during April, there doesn't seem to be anything conclusive. Right. We've got women overweight during pregnancy. We've got smoking.
On both sides of
both
it.
sides.
Smoking saying that it wasn't a
Right.
risk factor, and then smoking that it is a risk factor.
Right.
So go figure.
Environmental triggers, definitely.
The
Then
older dads.
older dads, certain genetic components.
Yeah.
So it seems almost more confusing than ever to me in terms of causation.
Yeah.
And except that we know genetic and environmental, we're continuing to say is the way it looks. So
yeah, and you know, with a lot of research, what we do is just come out with more questions,
Right,
and that's
more
kind of
questions.
the purpose of research. But it can be frustrating.
Well, one of the things that I know from my exposure is how much the arts can benefit our children.
Yes.
And you have a background in the arts.
Yes, that's what my master's degree is in the arts.
In art or theater art? Theater art, okay.
particularly.
Well, we had a woman named Stephanie Wilson on the show from the Gold Coast Theater Conservatory in Ventura County.
A lovely woman.
Yes, and she does a theater workshop for children on the spectrum, high-functioning autism and Asperger's. Now, my husband and I took Wyatt in to meet her and you know, be evaluated for the class. And he, of course, as often with our kids, when we're with them, they shut down. And we left, and my husband was like, he'll never cut it in that class. Well, he was in the class, and we went to a showcase last Saturday. It was amazing what we saw him do that we thought he would never do. Lines from Shakespeare, improv, doing something called bamboozle, where they jump in front of a spot and they have to, she gives them an emotion and they have to say bamboozle with the emotion. So he would go tired or bamboozle or bamboozle. So it was so great. And I saw him with his peers and interacting, and he said, I want to go sit with my friends, and I just saw the miracle of what the arts can do. So one of the things that I wanted to say was that I encourage parents this summer, because I think oftentimes during the school year with our children, we try to make sure they're staying up to speed with their academic work. During the summer, I think it's a great opportunity. If you do have a theater group in your area, if you have an arts group, you know, if you have even, I know there's all kinds of things, computer arts, theater arts. I encourage you to get your children involved with this, because you might unlock a social side of them that you never thought you would see.
Absolutely.
So I think that's a really important thing to remember this summer.
And I think it's important for everyone. You know, the reason why I got involved in theater to begin with was because I was so shy. I was so painfully shy. And my mother was, you know, saying to the pediatrician, I don't know what to do with this child. She's so shy. She has such an imagination, but so shy. And he said, oh, you know, put her in some kind of acting group. And, you know, it was life-changing for me. So for all of our kids, really, really important. Even if they don't end up in the arts, it can help them to relax. It gives them self-esteem, gives them a social situation. It gives problem-solving skills.
Yes.
So beneficial.
And there was actually a study at Vanderbilt University. They looked at cortisol. It's a stress hormone, and they measured it before, during, and after a theater camp. And in 3 different studies, it was found that acting improved the way kids expressed themselves, and their cortisol levels were lowered.
So there you go.
It really, it's miraculous, quite frankly. So I think I just encourage all you parents out there to do it. And ACT Today, Autism Care and Treatment Today, does fund camps and some theater workshops and things like that for families that don't have access or don't have the funds to do it.
And when's your next, I meant to ask you this before, when's your next period of time when you're accepting grant applications?
It's going to be another couple of months.
Okay.
Yeah.
Okay, so you just ended one.
We'll let you know,
That, and hopefully, because we talk about that a lot on the show, about people applying for those grants, and but we will let you know when the next grant phase is coming up. So a wonderful thing that you guys do.
Well, thank you. Okay, so we're going to come back with Valerie Vanaman, right?
Yes, we're going to take a
and
little
talk
bit of a break.
about IEPs and all kinds of things.
And the kinds of things that we need to know as parents when because we're all going to need to consult with somebody at some point about these kinds of laws. So Valerie Vanaman, when we come back, stick with us.
Welcome back to Let's Talk Autism with Shannon and Nancy, and we have a special guest with us today. Valerie Vanaman is an attorney specializing in special education, not only for children but for adults as well, right, Valerie?
Correct.
Okay, and we're happy to have Valerie with us today because we've got questions for her.
Yeah, it's such a thrill to have you here.
No, I'm glad to be here.
One of the things that we talk about is that sometimes you will need to consult with a special education attorney. What are some reasons that someone might need your services?
I think everybody approaches that a little differently. I think there are people who would say you always ought to do it first. When you first get started, find out, and then decide how to do it. There are other people who would say you go to some parent classes, watch programs such as yours, talk to people, become informed generally so that you basically have a sense of the law, have a sense of what's going on, so that you know when to go see the lawyer. Either approach, I think, works. I do think parents need to actively, aggressively, and always be associated with some parent organization, some entity, somebody who's putting out information, such as what you do here, that they can access, because you can't do this alone.
Yeah.
And then the question is, do the lawyers really know everything? They don't. They know the law. They don't know all of the information you provide. But if the parents have that kind of background, the signals that you may need a lawyer are really sort of 5 in nature.
Okay.
The first signal that you may need a lawyer is when the district says to you, or the people say to you from the district, we don't think your child has a problem that we need to address. Generally, that's a signal that there's been some predetermination that they're going to try and keep your child out of the system. Particularly for children who've had a lot of early intervention, who've done well with early intervention, who are presenting in a reasonably good form, as we say. Districts these days have to control costs. The first way to control costs is to have fewer people enter the system. So generally that's an indication that probably you want to go talk to somebody right away, because you really do need to know, based on your records, what you've got, what your situation is. The second time when you think you may need a lawyer is when they say to you, well, yes, your child is going to have some services, but we have a program here that everyone goes to. Now, if the everyone goes to program is not a program that you've heard good things about, or you've made some inquiry and you're not happy with, probably you need to go see somebody if you think you're going to need somebody special. The third situation is the situation in which the district will say to you, we can't get to you right away, or gee, we think this isn't working, but we can't get to it right away. The we can't get to things right away is usually another way in which you're being sidetracked into the unserved and underserved population, and you really need to probably go see somebody. The next item that happens is when you go through, and you may go through an IEP meeting on your own, and you hear things and things are said to you in the IEP that indicates either they don't think your child needs services, or they think your child needs a minimal level of services, or they think everybody's going to go into their program. Probably you need to go see somebody and see what you're doing. And of course, the fifth thing is when they simply deny you everything. By law, school districts, if they're going to deny you an assessment, if they're going to deny you services you've asked for, are supposed to send out a written notice called prior written notice. Generally, when you get those prior written notice letters, if you do get them, not all districts follow the law, you need to go talk to somebody with that in hand. Now, that doesn't answer the question, do I take an attorney to the IEP meeting? Do I not take an attorney to the IEP meeting? Not an easy question to answer ever. In some districts, it is the case you don't want to take an attorney to an IEP meeting, particularly if the parent has a parent support team to go along with them. In other districts, and my views have changed on this over the years, I think it might always be a good idea to take an advocate or an attorney who really knows what they're doing to the initial IEP meeting, so you as a parent can see what it ought to look like, and you get some on-the-ground training in how should an IEP run. So I know there are families now who in fact think that, let's do it the first time with a lawyer. People say, but isn't that going to make it too aggressive with the district? Again, it depends on what kind of feedback you're feeling about the district and what you've heard about the district in terms of what it does and doesn't do for kids.
Okay, wow, that's a lot of great information.
A lot of great information. Now, how does a parent, if they suspect, because sometimes, let's face it, Valerie, a parent can go into an IEP and everything sounds great. What's put on paper, and they're putting on a great show of support, and then you start to notice things going on with your child. You start to notice that your child, in fact, is not showing any indication of not only getting the education they need, but also is having a lot of behavioral issues, these kinds of things. And there was recently a very high-profile case in New Jersey, which I'm sure you are familiar with, where the father had issues. This is the Stuart Chavez case. The father noticed the child was having a lot of issues, a lot of behavioral issues, a lot of crying, lots of disturbing behaviors. So the father went to the extreme measure of wiring his child. What can a parent do within legal rights to actually go out and check out what's happening in the classroom?
Depends on where you live.
Okay.
And it's going to depend a lot on the law of the state as to what you can do or not do. But at a minimum, wherever you are, you have a right to go in. You may not be able to observe for long, but you do have some right to some observation. The minute you see that sort of stuff happening, you need to get yourself in there and take a look. Parents are, in fact, very acute observers of what works and doesn't work with their child. And getting in there even for that 20 minutes and seeing what's going on can give you a clue as to where things may be going wrong.
Okay.
In other states, in some situations, if it's really bad, you're going to have to get an expert who you're going to have to probably get to a lawyer and get that person in there to take a look at the program and what's going on. Parents should not ignore that behavior. A common excuse from educators is, well, we're in a transition period. He's simply adjusting to our new program. 3 weeks, 4 weeks, particularly with some of the social stories, for example, the cards developed and other agencies and people have developed over the years. Anybody who knows good autism programming knows that there's a whole series of transition activities that should not have a child after 3 or 4 weeks increasing in their acting out behavior, increasing in what's going on. Something's wrong. And you ought to use your instincts, get in there, take a look at it, and begin to figure out what's happening.
Great advice. You know what? I think we should take a little bit of a break,
Okay,
if you don't
we'll come
mind.
back. Yeah.
And one of the things that I want to talk about when we come back is insurance and how things are changing in some of the states. Things are changing a lot here in California. But let's take a break, and we'll be back with Valerie Vanaman in just a few minutes. Welcome back to Autism Live. We're here with our special guest, Valerie Vanaman. We're talking about special education and the laws surrounding it. And I know you had a follow-up question you wanted to ask.
Valerie, you mentioned that parents need to be on the lookout in certain areas, and one of them you mentioned was that if their child had possibly had early interventions and that the school was not giving them enough supports. What about the opposite situation? Shouldn't parents often be concerned if their child their abilities are being underestimated and they're being thrown into a class below their abilities?
And thank you for bringing that up. I guess I just assume that everyone knows that when they're not doing the right thing by your child and they're underestimating your child, that's of course number one. And I guess I just assume that. It just seems so automatic to me. But there is a lot of underestimation going on now, because if they underestimate, they don't have to serve as much in their view.
Right.
And so parents need to be right on top of that. If they've got you stuck off in a class of kids who are much lower functioning than your own child, or where you don't think your son or daughter belongs, you need to do something about it.
And in that situation, what should the parent do? Call an IEP? And
well, the parent should get their ducks in a row. And that may mean they want to consult with an attorney or an advocate, figure out what it means to get their ducks in a row, and then decide how are they going to approach it. Are they simply going to file for due process, or do they think they need to go through the IEP process? Each state, that's going to vary a little depending on how the judicial system in that particular state is looking at the situation, but that's a time to go talk to somebody. How do I begin to go after this? That's number one, of course, on the question of what do you need to know. Do you need a lawyer? You need a lawyer if, in fact, they've got your child warehoused somewhere.
Okay.
Wow.
The whole purpose of this law was to do away with warehousing, and unfortunately, as money gets tight, one of the things that's happening is we're going back to warehousing.
Now you're talking about the Lanterman Act in terms of the law?
Generally, everybody thing going tight. As there's less money for social services. California is a prime example at the moment. The folks who suffer are those least able to care for themselves.
Okay.
Instead of raising taxes and doing other things, we're taking it out on the backs of those least able to care for themselves. And that's exactly what's happening. And those kids are suffering, and they're suffering across the board.
Well, what can parents do in that case?
They can organize. I think all lawyers who've been in this field since its beginning, this law didn't exist before 1974. There was no law, and it only exists now because parents organized.
Okay.
National organizations of parents organized. Indeed, one of the, and this was an early organization, the Infant National Organization for Autism, I think it was called the National Autism Society, at the time when there were very few identified individuals, but the parents knew they had a struggle on their hands. They, in combination with parents who organized around other syndromes, were instrumental in having this law passed in 1974.
You're talking about IDEA?
IDEA.
Okay.
If it had
What
not
does
been
IDEA stand for?
Individuals with Disabilities Education Act.
And it had not been around prior to what year?
1974.
I can attest to that. I had a brother with Down syndrome growing up, and he passed away in 1994. And David was warehoused. You know, the schools at that time, you never saw the special needs kids.
If they were in school at all.
If they were in school at all. They were put in a special needs classroom, tucked away somewhere on the school campus.
Well,
they never came into contact
Well,
with
there's
the
a
other
seminal book that the Children's Defense Fund published in about 1972 that actually, I believe, our Secretary of State, Hillary Clinton, was a law student who worked on that book, in fact, at the time, called Children Out of School in America. And what it documented across the country, there were tens of thousands of kids with disabilities simply not going to school at all. And it was that force and the force of parents who got this law passed. Lawyers are not going to be able to keep this law in place. It is only organized parent groups actively talking about the fact that not only do we need this, but that it works. That it's going to keep it in place.
Isn't it also up to us as parents to be informed about what our lawmakers stand for and vote for people who support this law,
right,
and vocally oppose the budget cuts to our special needs students?
Absolutely crucial. And what's happened is school board associations and those who represent school boards have already begun a drumbeat to try and minimize the protections that are in the current law. And the only way that that current law is going to be retained with all the protections that must be there is if parents become informed and know about it and let people know that they're watching, that you cannot take this program away. It just cannot go away, because then we're going to be back into a situation where we have tens of thousands of kids sitting at home with nothing to do.
I had no idea, I'll be honest with you, that IDEA was at all being questioned or, you know, and I feel like I'm a fairly informed parent, that I had no idea that it had any danger attached to it.
There is, in times of government cutback. If you listen to everybody talk about the government shouldn't be in the business of doing this and government shouldn't be in the business of doing that, this is a relatively new law as these things go. Standing out there is one that can be snatched away at any time.
Wow.
Tomorrow, Congress could just eliminate it, and there we would be.
Wow.
That's extremely frightening. So I think it's very good that we're warning parents at home that they need to be very aware of what's going on and to fight for for their children's future.
Absolutely.
Now, you had a question about insurance that we were talking about.
Yeah, as we're talking about funding, and here in California, we have the regional centers that have been providing a great deal of the funding. I know that's the way my son got therapy, was largely through the regional center, a little bit through the school district.
As did mine, totally through regional.
And, things are in flux right now, and there's very little money for the regional center, and insurance is coming along. I'm just wondering from a legal perspective, what you're seeing, what you foresee, if there's anything you can say to any of us as we're looking at this.
I think there's three things that people need to keep in mind. First of all, the reason your children got services is because in California we have a unique law that, again, I will tell you, was the result of some real pioneers in autism in the state of California. Connie and Harvey Lapin were pioneers with some other groups getting through something called the Lanterman Act. And the Lanterman Act in California is a state-specific statute, could be gone tomorrow. If the governor decided that one of the ways to cut the budget is to simply wipe out the regional center system, there is no federal law or constitutional rights to have it stay in place. So again, it could be gone tomorrow. To the extent that people think, well, maybe that wouldn't be so bad because we're going to have insurance to pick it up, they're very short-sighted. Insurance companies don't pay out money easily. And even when mandated to do so, they're not going to pay out money easily. And they're going to be looking at this and looking at this and looking at this and finding ways, I have no doubt, to limit the hours of service that are actually given, to put constraints on them so that they're not true ABA programs, to do a variety of other things. It's not going to replace the regional center system. To the extent it helps us by supplementing it and by taking away some of the costs for the early, particularly younger kids, that's a great thing for the system. But it isn't the panacea, I think, that people think. And we frankly think that over the next 6 to 8 months, the law becomes effective July 1, that over the next 6 to 8 months, we're going to see lots of bumps, lots of holes, lots of ups and downs as people figure out what it is really going to look like.
Okay. I'm just really struck now. You've got two moms that were quite the mouthpiece together, and I'm hearing you say that something needs to be done on a federal level. What do we need? Do we need a federal law?
Here's what's happened. You guys came into an established system that pioneers before you put in place.
Yeah.
And then the lawyers sort of, the let's kill all the lawyers is the first thing.
Yes.
It's not always such a bad idea, particularly when it comes to things like this, because then the lawyers got involved and everybody just assumed this was the way it was always going to be. It's not how it's always going to be. Organized groups of parents, whether it under whatever name, that show that they have a membership that votes, a membership that's watching, and most importantly, a membership that says this stuff works. Because I think one of the pushbacks we're getting from schools is it doesn't really matter what we do. Your child, regardless of what we gave your child, would have looked the same at the age of 18 as they did when they came into the system. And that's because the people who are now the educators also don't have any institutional memory. They're young. They don't remember what it was like in 1974, 75, and 76, and 77, and 78, for that matter, indeed through the mid-80s, when the services were just beginning to gear up and just beginning to really become in place. And they just assume somehow that what they do doesn't make a difference. People are beginning not to, or trying to send a message that there's nothing special about special education. That's not true. There is something very special about good special education. And parents need to begin to talk about that. My child is different because, in fact, there was an effective program that did A, B, and C, and it's not true that he would have looked the same at 18 had he not had that. And that's a pushback that parents and organized parent groups have got to start to talk about.
Okay. But do we need to, this idea that IDEA could go away and that the Lanterman Act could go away, do we need to have a federal law? Is that what it's going to take so that we can have some insurance?
We have a federal law. It's called IDEA.
But if they can take it away...
But they could always take it away. What we have to do is keep it.
All right.
And so
the message has to be,
we have to elect public officials that support it first and foremost.
Okay.
We have to be ready to organize if it is in danger of being threatened. And between all of the autism, well, first of all, Valerie, 1 in 88. Talk about voting power.
Well, you know, I always thought, in my mind, I always said, oh, once this was passed, it'll never get taken away because everybody is 6 degrees of separation from someone with autism. And now I think it's probably closer to 4 degrees of separation from someone with autism. How is someone who knows this service matters and who knows special education support ever going to try and take it away? Well, times have changed in this country. There are a group of people out there who, even if they have it, we'll take care of our own. We're not going to be responsible for other people. So I think asking your elected officials who you currently have, are you supportive of this law and will you continue to be supportive of this law is absolutely crucial. And I think beginning to talk about the need to keep it, the fact that it's effective, it needs to stay. Because what you're going to hear, and it's already beginning, I'm telling you, there are some publications out there, some other stuff, where the drumbeat is, well, you know, we shouldn't give parents all these rights, they don't need all these rights, the school districts can police themselves. We'll tell them to do the program, but we'll let them decide whether it's good or bad, what they're doing. Then you might as well just throw up your hands because then it's all over. And we are going to be back to warehousing kids. The reason this law is effective, the reason we keep inequality at all in programs is because parents have a right to complain under this law and a right to go through in a process. And if we lose that, we've lost the battle, in my view.
Okay.
We cannot, then we are just back to warehousing.
Okay, we should take a break.
Yeah, and I have a couple of specific questions about the IEP process when we come back.
I would love to hear those. So stick with us. We'll be back with Valerie Vanaman in just a minute.
Hi, we're back with Let's Talk Autism. I'm Nancy Osbaugh-Jackson with Shannon Penrod.
Yes.
And we've got Valerie Vanaman here. And we're talking about, Valerie is an attorney specializing in special needs. And Valerie, I want to get back to the IEP for a minute.
Sure.
Individual education plan. A lot of parents newly going into the process, we're kind of old pros.
Yeah, now.
Now, yes. And if they're going in alone without an advocate or an attorney, can you go over a few of the things that they need to know? Because I didn't know a lot of things, like I could record it if I had permission, that kind of thing. Are there a couple of guidelines there?
Several things. First, it'll vary from state to state. In California, you're allowed to record an IEP meeting if you give 24 hours advanced written notice that you intend to do so. I used to say, don't bother to record it. I don't say that anymore. I think that you should, in fact, record every IEP meeting. But well, there are some exceptions. But mostly, I think, particularly if you're going by yourself, you should record it. And if your state gives you the right to do that, you should do it. In California, you have to be aware that in order to do it, you must give 24 hours written notice that you're going to do that. The second thing is this whole question that always comes up is, if the district's going to bring assessments and data and so on to the IEP meeting, am I entitled to see it beforehand? Unfortunately, the federal law does not have a requirement that it be shared with a parent beforehand, nor does in California the state law. That's not true in some other states. There are some other states where by state law the information has to be shared beforehand, so you need to check your own law on that. But in California they don't have to give it to you, except that what the federal law says is that you as a parent have a right to be an informed member of the team. And I've always said to them when they hand me this stack of things at the beginning of a meeting, how can we be informed members if we didn't have this material beforehand? And if it's extensive, and if I think there's problems in it, I will often say, you know, we're happy to have you go through this with us today, but we're going to need to reschedule for another session of this meeting so I can come back and look at it. Some districts will allow that to happen. There are some districts that are becoming quite user-unfriendly for parents, where they're simply going to say, no, you can't do that. Then I think the best you can do is say, I'm not an informed member. Make sure on the record you're saying, I'm not really informed. I haven't been able to go through all of this. I don't consider this to be a fair IEP meeting. But get through the process, and then I think you're going to need to go talk to somebody about what your options are. You do want to be as informed as you can be. You have a right in California to ask to have the reports prior to the IEP meeting, but they don't violate any law by not giving them to you.
Good to know.
You also have a right during the IEP meeting to ask questions. You should not feel that you're shut off. And if they're going to shut you off, and this will happen from time to time in some districts, there's one district now in Southern California that's become notorious for doing that. If they're going to try and shut you off, you should indicate, and this is a reason for having a tape recording, you know, I have a series of questions to ask so that I can be informed, and you're keeping me from really participating in this meeting and being part of the decision making by not allowing me to ask those questions. All of this should be done nicely. It should never become confrontational, even when they become confrontational with you as a parent, and that's now happening some because, let's be honest, in a time of limited resources and a lot of stress being put on special education people, they're feeling the stress as well. And now they find themselves with a parent who may take up more of their time than they want to give. They're feeling all the pressure. They're human. At the end of the day, they're human beings also. They get up and put their pants on one leg at a time like everybody else, and so you get this tug coming. It's very important for parents that they always, as hard as it is, maintain their cool, as it were. Be professional, be polite, never attack, simply ask. And make clear when you don't understand something and if your right to ask the question is being taken away. It's also the case that if they offer you a program you've never seen, you don't know anything about, you do not have to agree or disagree that day. You can say to them, I can't do that without going to see it. Mm-hmm. I need you to arrange for me to go see it. I can't agree or disagree without seeing it. The notion that you have to sign the IEP day, meet the document that day, you can't leave here without signing it. I don't know of any provision of the law that says that's the case. To the contrary, particularly if they're offering a program you've never seen or it's stuff you know nothing about, your right to say, I need to think about this, I need to be able to review it. And now in many districts you've got somebody sitting there with their little keyboard typing it all up. You don't even know what they're writing on the document. Yeah. And they hand you all these pages that you're supposed to sit there and read and sign. It's perfectly reasonable, and in fact I think parents would not be doing what they need to do if they didn't say, I need to take this home and read it carefully.
Okay. Yeah, I never knew that. I just assumed you had to sign it that day for years into the IEP process. Did you know that?
You know, the first thing that I had heard was, no matter what, don't sign it.
Okay.
No matter what they say.
Steered
and so
in the right direction.
there is one place where you have to sign
that
you were there. Attended.
Right.
And the first time I was like, no, I was told not to sign anything, and they said, this part you have to sign.
You
and
do
I was
have
nervous.
to sign you were there.
Yes,
okay.
But I didn't have to sign off. Or there's even a place, correct me if I'm wrong, that you can sign off on part of it, but I was told, don't sign it no matter what.
Even signing off on part of it becomes tricky, and if you're going to do that, you probably need to go consult with somebody. Okay. If you're not sure yourself how to sign it, consult with someone about how to sign it.
I was very naive. You know, when I went into the a preschool situation, I assumed everybody there was all there for the benefit of my son. They all were there to make him the best possible, fully functioning, educated individual he could become. And all these kind faces sitting around the conference room had his best interest in mind. Right. So after hearing everything they had to say, and they shoved it in front of me, I signed. Yeah. And it took,
I think that's a lot of people.
I do too, so I want to make sure that
And, you know, just to be clear, there are indeed many, many educators who are that way.
Yeah.
The problem is that they've got limited resources to work with. And for all children, it's not necessarily the case that they can provide what the child really needs in the course of an IEP meeting.
I want to ask, I want to ask about due process, because that's something that we have a right to, but even those words send fear down a parent's spine, thinking, you know, what is that? How would I go about that? Do I need a lawyer? Can you tell us a little bit about what due process is?
The federal law sets up a system whereby if a parent disagrees with an identification, i.e. eligibility decision, placement, or services that have been offered, they have the right to file for an administrative process. That administrative process will vary from state to state because the federal law allows either a single-step process or what is called a dual-step process. California, for example, we have just one hearing officer who hears it. There are other states where they have an initial hearing panel that hears it, and then somebody at the state reviews it. In California, it's a single hearing officer system. You file a complaint. There are certain requirements that have to be in the complaint. You have to be able to be specific enough about what the district's done wrong so the district knows what you're complaining about. Once that complaint is filed by federal law, and this is true across the country, the district has the right to require that you come to a resolution session. The notion of the resolution session came in the last round of reauthorization for the Individuals with Disabilities Education Act, when school districts went to Congress and said, we often don't know parents are unhappy. And if we just could sit down with them, we could resolve everything. And Congress bought that and said, well, we're going to write in this piece of the system, this resolution session, where we're not going to require the district to pay for attorneys. If the parent brings an attorney to that meeting, the district doesn't have to pay for it. But we really hope attorneys won't come. We really hope it'll be a place where the school people and the family can speak together. It hasn't, in California at least, worked out so well for lots of complicated reasons, not the least of which it wasn't true that districts didn't know there was a problem. They know when there's a problem. After the resolution session, if it's not resolved there, then there is the...
Is that called mediation?
No, then the second step is mediation. At mediation, in California at least, there are two kinds. There's what's called mediation without a subsequent hearing. It's called mediation only, or a mediation in which you try and work it out before you end up in an administrative hearing. At that process, at that time, someone comes in who acts as a mediator and tries to work with the two parties to reach a settlement. Prior to the last 2 or 3 years in California, about 95–96% of the cases were resolved in mediation. Because of some changes that have taken place in California, and districts having now an ability often to prevail in due process at a much higher rate than in the past, the mediations are not quite as successful as they used to be, but they're still an important tool, and many people do work out their differences in mediation. If it doesn't happen, and either side can waive mediation. There are some cases where a district says, we think we're so right that we're not even going to bother to try and resolve it. We're going to take you to a hearing. And that's then the administrative hearing. In California, that's done by a single judge from the Office of Administrative Hearings, who takes all the evidence, listens to the arguments, and then writes a decision. That administrative hearing is like a trial. It just doesn't happen in a courtroom. It happens generally in a school district office or an office of the Office of Administrative Hearings, and it's very much like a trial. Theoretically, parents are supposed to be able to do those on their own. There are parents who have done it on their own and have been more successful than lawyers have been. Wow. But those are usually parents with some legal background or some prior experience at doing that sort of thing. Generally, what you're going to find in most cases now that go to administrative hearing is there will be representation. It is the hardest, and when you say it strikes fear, I can understand that. Yeah. It is the hardest process a family will ever go through. Because over the course of a very short period of concentrated time, just given the nature of what has to be said in a hearing, you hear the worst about your child all in one time. Yeah. And none of us live that way. Right. None of us just think 8 hours, 12 hours a day only about bad stuff, because we'd all be in some sort of treatment then. And yet we require that parents sit through that and hear it, and it is draining for families, and I can understand that families don't like the experience, but sometimes it becomes the only option. And with a good attorney, with someone who's experienced and knows it, you try and make it as easy as you can, having said that it's going to be the most difficult process you ever go through.
I hate to cut you off, but we're like literally in the last 2 minutes of the show here, but we could sit here and talk for hours. Could we not?
Can I just ask, if the parent, if it is not ruled on the side of the parent,
they have a right to appeal to the federal district court.
Okay.
Okay. Well, thank you so much. Can we have you back again?
I'd love to come back.
Okay.
Because
Very good.
such a wealth of information.
When I'm not in triage mode with some of the districts around here.
I'm sure it is
Well,
IEP
Valerie,
season.
we really appreciate the work you do for our families.
absolutely.
It's nice to know that there are great attorneys who advocate for our kids, and I can't stress enough, we've got to keep voting for people that support our children. We have to keep these laws in place because they're always in danger of going away, and we have to protect our kids.